All right, so as the New York Manhattan District Attorney's Office continues their unhinged, politically motivated attacks on former President Donald Trump, there are many reports that District Attorney Alvin Bragg could be close to indicting the 45th president. Now, President Trump's attorney is formally requesting that the DA's office itself be investigated because it has so clearly been weaponized to target a single individual instead of being used to prosecute all the actual crimes that happen in New York every single day that are ignored. And Trump's attorney, Joe Tacopina, joins us now with much more. Do you believe, Joe, we've known each other a long time, do you believe these reports, they're everywhere, that they expect this indictment? Are you expecting it?
Listen, I still hold out hope that justice will prevail, Sean, because there has to be, and there is, in fact, a heavy dose of disgust in the legal community, in the bar, with prosecutors, defense attorneys, judges, that they're doing this. This is not what we do. This legal system has now been weaponized, completely weaponized. And you know, you could read that idiot Mark Pomerantz's book, who violated all sort of grand jury secrecy laws, had a fiduciary duty to keep things confidential, and instead wrote a book. And if you read his book, he even said, it was amazing what he admitted there, that he was just looking for a crime to fit the person. And that's not what we do. It's not what we should be doing. And clearly here, the Manhattan District Attorney's Office has stooped to that level if they are looking at this Stormy Daniels case. Because one thing is clear, that every single legal scholar, former members of the Federal Election Committee, have opined that no crime was committed here, that there was no campaign law violation at all.
Well, let me ask you this. There's an article by MSN.com, and the headline is "Prosecuting Trump for Stormy Daniels' Money Would Include Hurdles, According to Experts." At one point, they say if Bragg were to do this, it says it would be unusual for a state prosecutor to use an alleged violation of a federal law rather than of a state campaign finance law as a grounds to elevate a false paperwork case from a misdemeanor to a felony, but it would also be unusual to prosecute a presidential candidate for violating state as opposed to federal campaign finance laws. Do you believe that they're doing something this unusual? First of all, do you believe it's unusual on purpose, for the purpose of elevating what would otherwise be a misdemeanor in New York to a felony nationally?
Yeah, Sean, they clearly are. Look, any prosecution in this matter would be completely unprecedented, meaning this would be the first ever in the history of this country. And think about that. Think of that statement. Let that roll around your brain for a minute or two. Campaign finance laws are murky to begin with. And all the underlying legal theories that they have here that we've been hearing about from the Manhattan DA's office are untested, completely untested, and have never been utilized in this manner. So there are things here that, I mean, look at John Edwards. John Edwards, which was a completely different situation, right? You had a third party paying for room and board and rent to keep some woman that was pregnant with his child a secret, and that was a third party. And in fact, actually happened here. President Trump has denied from day one having an affair with this woman. What he is an extortion victim. And by the way, it's regardless of whether he did or didn't. He says he didn't. I believe him, and the evidence, I think, is very powerful that he never had an affair with her. But more importantly, he's a victim of extortion because she came out right before the campaign and said, or the election, and said, unless you pay me, I'm going to make a public story about something that he says is completely untrue. So that's something that would be done irrespective. And here's the key. It would be done irrespective of the campaign. Because as Michael Cohen, the convicted perjurer, liar, a guy who has zero credibility, I don't even think he had a law license, quite frankly. Honestly, what he said when he pled guilty, Sean, in this case, was that the client, his client, was doing it to prevent personal embarrassment and prevent embarrassment to his family. That takes it out of the realm of exclusively campaign finance. This is not a campaign finance law case at all.
Let me go back. I know you did an interview with Stephanopoulos this morning, and he asked you three questions. If the president authorized the payment to Stormy Daniels, was the payment properly recorded, and was it connected to the election? And
what I said was the only one that matters there is number three. Because if it's not connected to the campaign and had the purpose of affecting the election, then 1 and 2 do not matter at all. At all. It's not a crime. Nothing's a crime. So I'll go back to that again. This has to be tied to an election. And more importantly, the campaign finance laws. And there's a critical distinction separating campaign funds from personal funds. Here, this was all personal funds.
Let me ask, if I'm hearing you right, you're saying campaign finance laws are not, etched in stone, that they're somewhat ambiguous.
Yep.
And the underlying legal theories, and this goes to the MSN article, are untested. Explain what they mean and what you mean by that, and that other legal scholars and former members of the FEC have publicly stated in the past about this.
Sure, I have it right in front of me. For the purposes of influencing an election, that's what this has to be about. Solely for that purpose, not a primary purpose, has to be solely for the purpose of influencing an election. This payment, right, to this Stormy Daniels. So here is the statute's prohibition on diverting campaign funds for personal use. And there's a reason for that, obviously. You don't want people who are donating money to a candidate to all of a sudden have that candidate spend money on his personal items. I mean, anything in theory could be to influence the campaign, right, or the election. I mean, you want to campaign in a nice suit. You don't want to have a $20 suit made in China that's falling apart at the seams. You want to have a nice suit. That expenditure, in theory, according to this theory, could be a campaign finance law violation. Of course, it's not. So the crucial distinction is separating campaign funds from personal funds. Could you imagine, Sean, where we'd be tonight if President Trump had used campaign funds to make this payment? Oh, my God. They'd be calling for his scalp. Instead, he did everything the right way. He did nothing wrong, as he has said repeatedly. And so spending campaign funds from personal funds and separating those two is the critical distinction here. So personal funds and personal fund use, and I'm looking at the statutes regarding this, spending used to fulfill any commitment, obligation, or expense of a person that would exist irrespective of the campaign takes it out of the realm of what we're talking about here. Of course, this would exist irrespective of a campaign.
All right, Joe Tacopina, he's the president. He's the lawyer for the president of the United States, President 45, Donald Trump.